special fellows could add to what you have already in your storehouse of knowledge in order to ensure your passing the bar. You know, your reviewer this morning, and until we finish the entire book too, is Professor Salva, Nelson A. Salva. I am the head of the Critical Law Department in the School of Law of Arellano University and professor in several law schools in Metro Manila and paper reviewer in many review centers all over the country. I just got from Davao, where I lectured also on book 1. But the next weekend, I will also lecture on what I'm going to lecture through this schedule. So, in a way, this is only a rehearsal for my succeeding lectures in the other review centers. All right, you know, all your efforts during this review is in order to eliminate your ignorance of the law, especially those that are covered in the 2011 bar examination syllabus. You know, Justice Abad, who happens to be my classmate in Penn during AB days, had told us, unlike in the previous bar, there is no specification on what to read. And this time, he wanted it to be a little more specific. That's why he came out with this 2011 bar examination syllabus. I say to eliminate ignorance of the law. Ignorance of the law excuses no one from compliance therewith. But your ignorance of the law will not excuse you from passing the bar. Take note of that. And all the laws which you learn and discover in your adolescent years in the law school will have to be revived from your memory. You know, the adolescence age of all of us in the law school is from first year. But actually, in our actual life, the most wonderful age is adolescence, the age of adolescence, because that is the time when men meet girls. And on the other hand, girls become happy because they discovered that they are discovered. That is age of adolescence. Now, book 2 is divided into 14 titles. But the review here is more lengthy because of the additional special panels. We shall begin with title 1. This title was first read by you in book 1 because it is included in the 5 exceptions to the rule of territoriality of our criminal law under Article 2, the last of the 5 exceptions. Crimes against the national security and the laws of nation as they are defined in Title 1 of Book 2 of the Revised Penal Code. So it covers Article 114 up to Article 123. Now, first, treason. What is treason? Treason is a breach of allegiance of any national or citizen to his sovereignty. Allegiance is the obligation of obedience and fidelity to his country or state in return to the protection that that national or citizen received from it. There are 2 ways of committing treason in Article 114. They are, number 1, levying war against the government, and number 2, adherence to the enemy, living in aid in comfort. But remember, treason could only be committed in times of war. There is no traitor to his country unless the country is at war with the foreign power. And the offender, previously, in the crime of treason under our code, are only citizens of the Philippines. But before the outbreak of the Second World War, that provision of Article 114 underwent amendment through an executive order, making aliens residing in the Philippines also liable for the crime of treason. So both Filipino citizens and resident aliens are the ones liable. If aliens are not resident of the Philippines, then they are excluded. The citizens of the Philippines, wherever they may be, once they commit any act of treason, they shall be held liable and be held before our Philippine court. But with respect to resident aliens, they should be committing those acts only when they are in the Philippines, not outside of the Philippines. So the elements of treason act, there must first be, number one, the offender is a citizen of the Philippines or a resident alien. Number two, that the Philippines is involved in a war with a foreign enemy country. Number three, that this offender either levy war against the government or that they adhere to the enemy, giving them aid in comfort. Now, what is the meaning of levying war against the government? It means that the offenders shall assemble themselves. There must be actual assemblage of men for the purpose of carrying out treasonous design against the government by means of force. So, mere enlistment to fight the government is not enough to make one liable for treason. It requires actual assemblage of men in order to carry out the treasonous design against the government by means of force. And then we have the second mode of committing treason, that is adhering to the enemy and giving them aid in comfort. So mere adherence to the enemy without giving aid in comfort does not make the offender guilty of treason. What is the meaning of adherence? Meaning, intent to betray. The offender is entertaining intellectual and emotional sympathy to the enemy and an adverse sympathy against his home country. But that alone will not make him liable unless it is coupled by that second element, giving aid in comfort. And what does aid in comfort means? That aid must have the effect of strengthening the effort of the enemy in fighting our government. Mere giving women to enemy soldiers or army, commanding all women in order to give them entertainment. The Supreme Court said that is not the concept of giving aid in comfort, although giving them women entertainment will boost their morale. It does not fall under that concept of strengthening the effort of the enemies against our government, said the Supreme Court. So kahit na ibigay ng traitor yung lahat ng mga prostitute sa ating bayan sa Pilipinas para sila ay aliwin, hindi raw yung crime ng overt act of treason. Bakit kamo? Eh kasi common sense, lalo lang silang manghihina kapag kayo lang ginawa nila. Lalo lang silang manghihina. It weakened them. Then, so giving foodstuffs, supply of foods, giving armaments will constitute overt act of treason. There are two ways of proving treason. Or the question would be, what is the quantum of evidence required to prove treason? Now, under the second paragraph of Article 114, it says, no person shall be convicted of treason unless upon the testimony of two witnesses at least to the same overt act or confession in open court. So those are the two modes of proving the crime of treason. Either that two witnesses are presented testifying to the same oferta. That is the so-called the two-witness rule. And the other one is when during arraignment in open court. And that court must be a court of competent jurisdiction which could render judgment of acquittal or conviction as the case may be. And the accused in that open court makes an admission of his guilt, confession of guilt in open court. Meaning to say, he confesses that he had committed the act of treason, either by levying war or adhering to the enemy, giving them aid in control. And how will you apply this to witness rule? When shall it be considered to have been complied with, so that it will result in the conviction of the accused? Well, these two witnesses must testify to the same overt act. Meaning to say, if for instance there are two overt acts committed by the offender, a Filipino citizen. The first is delivery of truckload of rice to the enemy garrison. The second, delivery of 100 pieces of automatic rifles to the enemy. There were two witnesses presented by the prosecution. Witness A testifies to that overt act of delivery of rice to the enemy garrison. Then, witness B was presented, and this witness B testified he saw the same offender deliver these 100 pieces of automatic rifles to the enemy. Those are the only evidence presented by the prosecution. Can that result to the conviction? There are two witnesses testifying to overt act. The answer, no, it will result to the acquittal. Because while there are two witnesses, each one testified to an overt act different from the other. When you speak of testifying to the same overt act, if there is an overt act of delivery of 100 pieces of armored rifle, those two witnesses must testify to the overt act. And also, the two witnesses shall testify to the fact of the delivery of that truckload of rice to the enemy. That is how these two witness rules should be applied. And remember, even if there are two witnesses who will testify to the same overt act, it requires that both must be credible per the assessment of the court. Because if only one of them is found to be credible, then the two witness rule is not complied with. It will result likewise to the acquittal of the accused. Remember that treason is the only felony under the revised penal code requiring these two witnesses to testify on the same overt act. No other felony. Why is it so? Because the crime of treason, which has a very severe penalty, is committed during abnormal times. And during abnormal times, like war, people may, in a small squabble, may forget there is purpose and may sacrifice thoughtfulness. Thus, if there is no two-witness rule, one who is entertaining some peeling of pretense against a Filipino during wartime, in order to get even with him, that sole witness may be tempted to file a complaint for treason against that man and testify against him. Because he has given the enemy aid and comfort. He adheres to the enemy. If he is a good false witness, there is probability that the court may be persuaded to believe his testimony, and that will result to the conviction of the accused. That will be a grave miscarriage of justice. To avoid that situation, the law requires this two-witness rule to apply strictly in cases of the crime of treason. That is the reason for this two-witness rule. Now, of course, in proving treason by confession of guilt in open court, it must be in open court before a court of competent jurisdiction. extrajudicial confession will not suffice because that is not confession in open court. Now, you have covered in your study of Book 1 about Article 8, conspiracy and proposal to commit treason. They are preparatory act which, as a rule, are not punishable unless there is a specific provision of law providing penalty for. That exception is found in Article 115 as one of them, because there are felonies in the revised penal code, few of them only, where the mere conspiracy and mere proposal to commit that felony is already punishable by law. Conspiracy and proposal to commit treason. But unlike in treason, where the two-witness rule will apply, here, in conspiracy or proposal to commit treason, that two-witness rule does not apply. Why? Because that is a distinct crime from treason. It is only in the crime of treason itself where this two-witness rule shall apply. And there is conspiracy to commit treason when, in times of war, where the Philippines is involved, two or more persons come to an agreement concerning the commission of the crime of treason, either by levying war against the government or by adhering to the enemy, giving the made in comfort, and decide to commit it. So the elements that must always be remembered is there must be a war in which the Philippines is involved. Then two or more persons come to an agreement to commit that crime of treason in either of those two modes. And lastly, that these two or more offenders have decided to commit the same. Absent the decision to commit the crime of treason will not make such conspiracy a punishable crime. That last element is always necessary. And remember that this Article 115 gives you the concept of conspiracy and proposal as a crime in itself. That is the concept, because you learn that there are two concepts of conspiracy. Concept as a crime and concept as a mode or manner of incurring criminal liability. There is proposal to commit treason whenever a person has decided to commit the crime of treason, either of those two modes mentioned, and proposes its execution to some other person or persons. The moment this proposal is accepted by those two or more persons, then the crime for which they shall be prosecuted is for conspiracy to commit treason. There is no more crime of proposal to commit treason, because proposal to commit treason will only exist if such proposal has not been accepted by those two or more persons. Why conspiracy will be the offense to be prosecuted? Because the one who made the proposal and those who accepted the same will now fall under the definition of conspiracy when there are two or more persons come to an agreement to commit that felony of treason and decide to commit it. So, by mere agreeing, they become all liable for conspiracy to commit treason. That is the concept as a crime in itself. But the moment overt act of treason is in itself committed by those conspirators, they shall not be liable anymore for conspiracy. They shall be charged and be convicted of the crime of treason. What happens to the conspiracy? It shall merely become a mode of incurring criminal liability. And the principle of conspiracy, the act of one is the act of all. Then we have this crime by omission. Article 116 provides for the crime of misprision of treason. According to the provision, any person owing allegiance to the government of the Philippines without being a foreigner who has personal knowledge of any conspiracy against the government shall disclose the same as soon as possible to the public authorities mentioned in that provision, provincial governor or provincial prosecutor or fiscal, city mayor or city fiscal. Now, who would be the offender in misprision of treason? Now, you know, in 2010 bar examination, one question about this provision was asked. Only citizens of the Philippines. Resident aliens are not included. Why? Because the very sentence, any person owing allegiance to the government of the Philippines without being a foreigner. A resident alien is a foreigner. Who is not a foreigner who owes allegiance to the government? Citizens of the Philippines. Pinahirap lang ng lawmaker para binigyan tayo ng rebate. Sasabihin, any citizen of the Philippines. Dapat ganun na lang ang sinabi. Pero sinabi, any person owing allegiance to the government of the Philippines without being a foreigner. Iman din dapat. Siguro tinitest talaga kung magaling tayo mag-intindi ng batasan. At kung hindi, gagawin na lang na citizen of the Philippines. Simple. Alright, the omission there is the failure to disclose as soon as possible. But remember, what must be disclosed is mere conspiracy to commit treason either by levying war or adhering to the enemy, giving the waiting comfort. So once two or more persons have already consummated the overt act of treason, it came to the knowledge of a Filipino citizen, but he fails to disclose the same to the proper authority, he has not committed any crime at all. Because what the law is specifically mentioned or referred to is the failure to disclose conspiracy, personal knowledge of a conspiracy against the government, not a consummated act of treason. And upon conviction, according to the law, the penalty shall be the penalty for an accessory to the crime of treason. Meaning to say, 2 degrees lower than the penalty prescribed by law for the crime of treason. But can the convict of violating this Article 116 be entitled to the exemption provided in Article 20 of the revised penal code? Accessories who are spouses, descendants, ascendants, legitimate, natural, or adopted brothers and sisters, and the relatives by affinity in the same degree. Can they be entitled to the exemption provided under Article 3? No. Why? Because the offender in violation of Article 116 on misprision of treason is a principal. Remember, he is a principal. What the law mentions there is that once convicted, the penalty to be imposed is as an accessory to the crime of treason. But he remains to be the principal, and therefore he is not included in the provision of Article 20, who may be entitled to the exemption from criminal liability. Now, is there any defense about, for instance, a Filipino not being able to report as soon as possible that knowledge of his personal conspiracy against the government? Yes. Don't forget to remember paragraph 7 of Article 12. When the offender pays to perform the duty required by law, and that duty under Article 116 is the duty of reporting any personal knowledge of conspiracy. If he fails to do and perform that duty, if the reason is by lawful or insuperable cause, then he is exempt from criminal liability.
simple illustration is when, for instance, Series X, a Filipino citizen in his barrio, he learned personally 2 or more persons of his barrio mates had conspired to commit treason against the government. But at the time, there was a strong rain that caused immediate flash flood up to the deep neck water with a strong current of water. To pray those strong current of water, definitely he will die. So he was not able to report as soon as possible that knowledge of conspiracy. Hence, he falls under that paragraph 7 of Article 12, exempting circumstances, failing to perform a duty required by law when prevented by some insuperable cause. Flash flood is a particular event. It is not man-made. Also, in the case of a priest who heard confessions of 2 or more persons confessing that they had conspired against the government, and the Catholic priest who heard the confession did not report it to the proper authorities. If somebody learned, this priest never did so, that of reporting, he could be charged for violation of Article 115. But is there any defense that he could successfully put up? Yes. There is a local cause why he did not report it as soon as possible. And what is it? The constitutional provision guaranteeing the free exercise of religion, meaning it recognizes the canons of different religions. And under the canon of Catholic religion, priests are prohibited from disclosing those matters learned in confidence by them during confession. So, they are exempted, prevented by some local cause. Then we have this espionage, Article 117. Now, espionage generally means the gathering and transmitting of any information that is detrimental to the security of the state. As a general definition, it could be made like that. But on the manner of commission, Article 117 provides the 2 modes of committing the same. There are 2 paragraphs there. In the first paragraph, the offender is any person, whether a citizen of the Philippines or a foreigner, or a private individual or a public officer. There is no distinction. And then he enters any warship or reservation, military reservation, without local authority. And his purpose is to obtain information, data or photograph of confidential character relative to the defense of the Philippines. And number 2, that pertains to a public officer who, by reason or by virtue of the position he held in the government, he has custody and possession of those information or data that are mentioned in the first paragraph thereof, and then delivers the same to the representative of a foreign country. So, espionage is not dependent on the citizen to become guilty. Any person, for that matter. Unlike in treason, where both citizens and resident agents are the ones who could be charged and be convicted of the crime of treason. Now, the public officer under the second paragraph, if the documents, photograph information relative to the defense of the government are not of confidential character, will he be guilty of espionage? The answer is no. But he is liable for infidelity in the custody of papers or documents under the provision of Article 226 of the revised penal code. That is the crime. Because under that second paragraph, the element is that information of data must be of confidential character or nature, referring to the defense of the country. So, if it is not of confidential nature, but still, They are documents or paper that are entrusted in his official capacity as public officer. The removal thereof, the giving away thereof to any person will then constitute the crime of infidelity in the custody of document or papers, which is squarely defined and penalized in the provision of Article 226 of the revised penal code. Under Title 7, crimes committed by public officer. Under the first paragraph, the first mode of committing espionage, it is not necessary that the offender has actually obtained those data or information of confidential character relating to the defense of the country. It is enough that it is proven by evidence that his purpose in coming to that place without local authority is to secure and obtain those documents, data, photograph. Even if he is not actually able to secure and get those information, he is already guilty of violating Article 170. Now, there are other crimes covered since it is also stated in the syllabus. It is worthwhile to also revive it from your memory. Like, for instance, we have the crime of violation of neutrality. And correspondence to enemy country or enemy held territory, or flight to enemy country. Now, with respect to violation of neutrality, it implies that there is a war between and among nations, but the Philippines is not involved. And to maintain the neutrality of the Philippines, the proper government authority issues rules and regulations for the maintenance of that neutrality. And then any person who violates that rules or regulation that maintains the neutrality of the country in the war, that violator will be deemed guilty of the crime of violation of neutrality. Then the crime of correspondence to enemy country or enemy held territory. How is it committed? There are three modes of committing the same. There is a war between the Philippines and the foreign country. Number one is, if there is prohibition to make any correspondence to that enemy country or enemy held territory, any kind of communication by means of letters, whether it contains harmless, even if it is merely love letter, as long as the prohibition says no communication whatsoever shall be made between the Philippines and that foreign country or enemy held territory, the offender is already liable. The second one is assuming there is no prohibition, but the communication or letter is carried out by means of sign, ciphers, or symbol. That is already violation, even if there is no prohibition imposed by the government. And lastly, even if there is no prohibition, but the communication itself carries information that is detrimental to the security of the state, then that is already punishable. And if the nature of that communication is such that it will help the enemy country defeat our defenders, then the penalty shall be the same as in prison. The same penalty for prison shall be imposed under the provision of communication against communication with enemy country or enemy held territory. Then we have the crime of flight to enemy country. This will be committed only by any person, whether a citizen or resident alien, who, after the government has prohibited or imposed a prohibition to fly to enemy country, he flies there or attempt to fly to that enemy country. The mere attempt to fly, as long as there is prohibition, consummate the crime of flight to enemy country, which is penalized and defined under Article 121 of the revised penal law. And then crime against the law of nation, which is, of course, always to be remembered, piracy and mutiny in the high seas or in Philippine waters, Article 122. That Article 122 in its original provision does not have this crime of piracy or mutiny in Philippine waters. It is only by virtue of the Republic Act 7659, the heinous crime law, which introduced that amendment by adding or in Philippine waters. So, piracy and mutiny could be committed either in the high seas or in Philippine waters. While you read the provision of Article 122, you will have actually the idea of what is piracy, because it is specifically defined there. But you could not see any that will give you the idea what is mutiny, except the mere mention of the word mutiny. So to be able to know what is mutiny, you have to read your textbook. And what did you learn from your textbook? Mutiny is the creation of disturbance or commotion in the vessel, in authority, in defiance of the authority of the ship commander or ship captain. That is how mutiny should be understood, because we don't have anything that will give you idea what is mutiny under the provision of Article 120, except that definition of piracy. Now, how is piracy committed? It is committed by attacking any vessel or seizing the cargo of the vessel or seizing the belongings of the complement of the vessel, whether crew members or passengers. Those are the acts constituting piracy under Article 122. And who are the offenders? The offenders under Article 122 are only strangers to the vessel. Complements, passenger or crew members are not included. But Justice Florence Picalado, in his book, Confectos in Criminal Law, the only remote possibility that a passenger or a crew member could be likewise liable for piracy is if conspiracy is proven. Because conspiracy creates the vinculum between the minds of those strangers and the passengers or crew members, which will make them equally liable, because once conspiracy is proven, the act of one is the act of one. But absence conspiracy, only strangers to the vessel could be offender in the crime of piracy. Now, how do you define piracy now? Well, the internationally known definition is that piracy is a depredation or robbery in the high seas, done without lawful authority and with animo curandi, in the spirit of lawlessness against the community of nations. That's why it is called a crime committed against the whole community of nations. Thus, piracy, wherever committed, may be punished in any of the countries where pirates will seek refuge. In mutiny, of course, they challenge the authority of the ship captain. They create disturbance or commotion, and the offenders here are complements of the vessel. They could be the crew members together with the passengers, or passengers alone, or crew members alone. And in mutiny, unlike in piracy, intent to gain is not an element. Intent to gain is only incidental to the commission of duty. But in piracy, it is always present. The element of intent to gain is there in the crime of piracy. In Article 123, it provides for the so-called qualified piracy. That is the caption of Article 123. There is no mention about qualified mutiny. But there is also qualified mutiny. Because if you read Article 123, it speaks of the offenses mentioned in the preceding article, which is Article 122. And there are two offenses mentioned there, both piracy and mutiny. So you should not be misled by the caption of Article 123, which says qualified piracy. Mutiny is not mentioned. And how it has become qualified? When any of those enumerated in the three paragraph circumstances that are found in any of those paragraphs are present. Number one is when the offender shall board or fire at the vessel. So, you could easily conclude that this qualifying circumstance number one will apply only to strangers because they will board the vessel. Whereas, those the mutineers are already on board. So, it applies only to the case of piracy, not to mutiny. But the second and third could apply to qualify both piracy and mutiny. That of abandoning the victims without leaving them any means for survival. Whether piracy or mutiny, that could be employed. And number three is when the crime of mutiny or piracy is accompanied by murder, homicide, physical injuries, and rape. So in other words, there could be no more complex crime of piracy or mutiny with murder, or with homicide, or with physical injury, or rape. Because the moment those crimes are committed during the occasion of piracy or mutiny, that is already qualified piracy or qualified mutiny. No longer to be charged with two separate offenses or shall complex the same with each other. Don't forget that we have a special law punishing piracy in Philippine waters, PD 532, where it is committed by attacking or seizing any vessel, or seizing the cargo thereof, or the belongings of the complements, whether crew or passengers thereof, by means of violence or intimidation, or force upon things, while the vessel is in the Philippine waters, committed by any person. So, you will now draw the distinction between piracy under Article 122, which could also be committed in Philippine waters, with this offense of piracy in Philippine waters covered by Presidential Decree 532. Take note, first, in the crime of piracy under Article 122, there is no mention on the manner how it will be committed. But in piracy, under PD 522, it states, by means of violence or intimidation of person or force upon means. And the offender is any person. So in piracy in Philippine waters, whether he be a stranger or a member of the complement or a passenger, as long as he commits that attack or seizing of the vessel of cargo inside that vessel by means of violence or intimidation of person or force upon thing, that is piracy in Philippine waters. But suppose those pirates or even the complement in the middle of the night, they steal without the consent of the owner, the cargo belonging to the ship or belonging to the passengers or crew members. Will that be considered piracy in Philippine waters under PD 532 or even in Article 122? The answer is no. Why? In PD 532, it specifies the manner by which those property shall be seized, either that it is by means of violence or intimidation of person or by force upon things. If it is taken without the consent of the owner and no violence or intimidation of person or force upon things are employed, the crime is imported under Article 308. And if it is committed with abuse of confidence by the crew members, then it will be qualified theft, which shall be covered by Article 310 of the revised penal law. Then what is Philippine waters? And what is a vessel for purposes of applying this PD 532? Now, vessel refers to any watercraft used for movement of persons or transporting goods through Philippine waters. And it includes any watercraft which may consist vessel or even fishing boats. And what is Philippine water? Oh, any water belonging to the Philippines. Those that are surrounding, connecting all the islands of Philippine archipelago, regardless of depth, width, or dimension. And those waters which the Philippines has historic or legal title, including the territorial water, seabeds, and other portion of the waters over which the Philippine government exercises jurisdiction. That is the meaning of Philippine waters. So I hope, by the way, suppose persons assist the pirates under PD 532 or acquires and obtain any of proceeds of the crime of piracy or gain or derive profit thereon. What is the liability of those persons? Now, under the provision of PD 532, they shall be considered accomplices in the commission of the crime, accomplice to the principal, and they shall be punished according to the rules of the revised penal code. So this is a situation where accomplice is punished by the special law, but the penalty is found in the revised penal code. As a rule, in violation of the special law, only the principal is liable. There is no accomplice nor accessory. The exception only is when the provisional law itself provides punishment for mere accomplice or as an accessory in the commission of the crime of piracy in Philippine waters. So there is no accessory here, because even those who derive profit are considered accomplices, and they shall be penalized 1 degree lower than that penalty prescribed for the principal in the crime of piracy in Philippine waters. Then the other penal laws, special law, that is considered included according to the syllabus is the anti-hijacking law. The anti-aircraft hijacking na tinatawag. Ano bang feeling ng Republika? Basta anti-hijacking, hindi naman kayo nire-require na examine yan, nasabihin pa ang Republika at saka yung mga PD number. Baka magkamali pa kayo ng pagkasabi ng number, baka i-minus pa sa inyo yun. Kaya according to law na lang. According to law. Kaya ko lang naman nababanggit ito as reviewer ninyo, at least naman, alam ko yun eh. Bakit hindi alam niyo siya? Sabi ko, ba't alam namin? Kung hindi ko man alam na rin natin na yan ay part of the law. Sabi na natin sabihin natin, para tayo hindi nagkakaingita. So, what are those acts, punishable under this anti-hijacking law? Number one is, by seizing the control of the airplane or compelling that aircraft which are registered in the Philippines when such aircraft is in flight. What is the meaning of the aircraft is in flight? When all the exit doors are closed from the place of embarkation up to the time it reaches the place for this embarkation. That is in flight. Yung kanilang exit door is still closed. That is the meaning of that, when the exit door are closed when the aircraft is in flight. So it applies only to aircraft that are registered in the Philippines. The second act is when seizing the control of an aircraft that is foreign aircraft, or compelling the same to land in the Philippines. There is no requirement that it shall be in flight, only in Philippine registered aircraft where the requisite of in flight is provided. The third act is when carrying any substance to aircraft used for public conveyance, substances that are corrosive, poisonous, explosive, or flammable, they are prohibited. And when it comes to cargo aircraft, the same substances carried and loaded in violation of the rules and regulation by the Air Transportation Office. I think it is no longer the name of that office, it has been changed. But whatever is the name, it refers to that office regulating the flight of aircraft, whether domestic or foreign aircraft. Those are the punishable under the special law known as the Anti-Hijacking Act. Now, another special law, this is a very new one, which really requires some focus in order that the same may not be missed by you during the bar examination. Kasi merong dahilan kung bakit isinama specifically ito rito. So I say, it is dangerous for you to be afflicted with amnesia, whether partial or complete during examination time. So, iwasan ang sakit na kalimot. Yan ang feeling ko sa inyo. Now, this Human Security Act, which is Republic Act 97, not 97. Magkamali ako na Human Security Act of 2007. Republic Act 93, 72. This is the Republic Act. Now, according to the Black's Law Dictionary, terrorism refers to or involves violent acts that are dangerous to human life. It seeks to intimidate the populace and influence the policy of the government. It is a crime against the laws of nation. Now, under the provision of Human Security Act, what is or how do you define terrorism? Now, terrorism is a crime which is committed by any person who commits any of the following crimes divided into two classifications. 1, 6 felonies are specified in the definition of terrorism. What are these crimes? Piracy and mutiny, under Article 122, rebellion or insurrection under Article 134, coup d'etat under Article 134-A, murder, Article 248, kidnapping and serious illegal detention, Article 167, and crimes involving destruction, Article 324. 6 felonies that are specified in the definition of terrorism. And or any of the following crimes punished under special law. Another 6 na naman ito. Isang dosena itong lahat na crimes na ito, if committed, it may form as an element of the crime of terrorism. Now, what are those 6 crimes punished by special law? Arson under PD 1613, then violation of Republic Act 6969, otherwise known as Toxic Substances and Hazardous and Nuclear Waste Control Act, then violation of Republic Act 5702, Atomic Energy Regulatory and Liability Act, and then number 10, Anti-Hijacking Act, Republic Act 6235. Then we have the 11th, Anti-Piracy and Highway Robbery Law, PD 532. And finally, PD 1866 as amended by RA 8294, which is the crime of illegal possession and use of firearms and explosive law. You can commit any of the crime. And this commission shows, thereby showing or creating any condition of widespread or extraordinary fear among the populace to coerce the government to give in to unlawful demand. So, be sure, madali naman intindihin this any crime na in-enumerate, 12 yun, 6 covered by the revised penal code, and the other 6 punishable by the special law. And the commission thereby causing, thereby showing, and creating a widespread condition, create widespread and extraordinary fear or panic among the population, in order to coerce the government to give in to unlawful demand. Now, if you will see how these specific crimes are committed, if for instance a person commits murder and it creates widespread chaos or fear among the populace, and the purpose is to coerce the government to give in to some unlawful demand. Alright? It becomes terrorism. But remember, if it is only homicide that is committed, it is not included. Even if it's so fear, widespread at that, it is not terrorism because the law specifies that it should be murder. It should be murder. Unlike in some provision of the revised penal code, where the use of homicide is in its generic sense, that covers even murder and infanticide, like the robbery with homicide in paragraph 1 of Article 294. You learn that that use of homicide is in generic sense, which covers even murder and parricide or infanticide. But in the specific definition of terrorism, it should be murder that is committed. That created widespread fear and panic among the population. If piracy in Philippine waters is committed, and it creates widespread and extraordinary fear among the populace, and the purpose is to compel the government to give in to some unlawful demand, then it will give rise to terrorism. However, if the information is filed for terrorism, and these crimes that I enumerated, which are all 12 in all, if let's say murder is the a crime committed, a predicate crime, but which created widespread panic and fear among the public. If during the trial in court, the elements of terrorism are not proven, but murder, which is alleged together with the specific elements, are proven, then the court can convict the accused merely of the crime of murder and not terrorism. Because murder is necessarily included in the crime of terrorism, which, if properly alleged with all the elements of murder, proven by evidence during the trial, but the other elements of terrorism, like creation of widespread panic, are not shown by the evidence, then the accused shall be convicted only of murder and not terrorism. The same is true with piracy, or let's say rebellion, codita, kidnapping, or arson. If all the other elements of terrorism are not proven, but these specific crimes, which are properly alleged together with the elements in the information, are proven by competent evidence, then the offender shall be legally convicted of these individual crimes and no longer for terrorism. Now, there is also a crime of conspiracy to commit terrorism under the law, Human Security Act. It is defined and is penalized. So, all conspiracy to commit terrorism is punishable. The act of accomplice is also punishable. An accessory to the crime of terrorism is also punishable. But the law, this Human Security Act, provides exemption, very specific, according to that provision of the Human Security Act of an accessory. Those accessories who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degree, except accessories who profits himself or assisted the offender to profit by the effect of the crime, shall be exempt from criminal liability. But it does not specify this provision of Article 20 in the revised penal code. This exemption is specifically provided by the provision of the Human Security Act, without express reference to the provision of Article 20 of the revised penal code on exemption of certain accessory. We will have a short receipt at 10:30 para naman makapag-relieve tayo, ano ha. Pero maya-maya pa kasi wala pa eh. Inuurasan ko nga, baka mapasobra. Eh, magalit naman kayo kung tuloy-tuloy ako. Alam mo, kung isa para akong yung diesel engine eh. Pag nag-iinit ka, gusto ko tuloy-tuloy na agad ang takbo eh. Ha? Kaya from time to time, I'm looking at my watch. Now let's go to the fundamental, the crimes against fundamental laws of the state. This title, or crimes embraced on this title, is very important to all of us, because all these crimes are against the provision of the Constitution, especially the Bill of Rights. Like, for instance, arbitrary detention. What is the particular constitutional provision? No person shall be deprived of liberty without due process of law. One bar examination, all my students expressed elation and happiness because my favorite question was asked in the bar examination. So, automatically, they said, aba, mukha ni sir ito, nakikita namin sa question na ito. Ito ang madalas na ibibigay niya. sa book 2, during first year, o kaya kahit na sa review. What is that? What are the different classification of the crime of arbitrary detention? There are three. The three successive articles, 124, 125, and 126, are the ones that make arbitrary detention divided into three classifications. Article 124, arbitrary detention, proper I should say, because that is the only among the three articles that mentions arbitrary detention. So I say arbitrary detention proper. And how is it committed? It is committed by any public officer or employee who detains another without any legal ground. It mentions about public officer or employee. Thus, it includes all public officers which are covered by the definition of the term public officer, which you can find in Article 203 of the revised penal code. Remember, the term public officer is defined under Article 203. But if you will see that definition, it covers all public officers in the government, from the highest position, the President of the Philippines, down to the lowest functionary of the government. Are they included in the definition of the crime of arbitrary detention? The answer is no. There are only two classifications of public officers who could be offended in the crime of arbitrary detention. And they are, number one, those public officers who have the power to order the arrest of a criminal. And number two, those public officers who have the direct power to effect the arrest of a criminal. So, judges, prosecutors belong to the first. Mayors, governors, President of the Philippines, they have the power to order the arrest. Even barangay captain. Now, with respect to the other category, those who have the power to directly arrest offenders, then we have the members of the law enforcement agencies like the policemen. And this will include even the what I used to mispronounce barangay tagay. Pero barangay tagay, barangay tagay kasi nabibisit ako doon sa mga barangay na nag-duty. Eh walang ginawa kundi magtagay na lang na magtagay ng mga demonyo. Kaya tuloy nabitin demonyo sila paminsan-minsan. So, a mere clerk, chief clerk in an office is a public officer. The secretary of the Sangguniang Bayan is a public officer. The secretary to the mayor is a public officer. But if they detain a person without legal ground, definitely they will not be held liable for a violation of Article 124 because they are not included there in the phrase public officer or employee. That crime would fall under Article 167 or 168, which is illegal detention, not arbitrary detention. And what is the meaning of detention? Does it necessarily mean that they shall be, or the person detained shall be placed in an enclosure? The answer is no. Even if they are not placed inside the enclosure, outside the house, outside the cell. But the person detained could not live at their own free will because there is always a guard, or that they could not live even without a guard because of duress that is already embedded in their minds by the offender. At umalis ka dyan, pag nakita kita agad, dead ball ka na. I will also massacre your family. So, sa takot ng tao nakadetain, nandun lang siya sa labas. Paikot-ikot siya ron, pero hindi siya makalayo. According to the Supreme Court, that is covered by the term detention. And that decision of the Supreme Court applies to both detention and illegal detention under Article 167 or 168 and in the definition or in the crime of arbitrary detention. Now, what are the legal grounds for detention? Then that other paragraph of Article 124 says, commission of a crime, whether consummated, prostrated, or attempted, or when the police officer have reasonable ground to believe that that person has committed a crime, he could detain. So outside of those, it is not. What is the other legal ground mentioned? Violent insanity of the person detained. And the last one is those suffering such illness which is contagious, that requires confinement. So tatlo yun. Commission of crime, violent insanity, such illness that will require confinement to hospitals of those who are sick, of those necessarily they shall be contagious diseases or illness. Now, the second classification is arbitrary detention by delaying the delivery of a detained person to the proper judicial authority. Delivery by the offender who is a public officer, meaning to say, he will only file the proper complaint. It is not required that the person detained, bubuhatin niya, dadalhin sa judicial. No, it's not. Pwede nakalagay sa council, pero tapos na ang kanyang investigation, yung complaint ready, ipapile na lang niya doon sa proper judicial authority. Hindi kasama yung tao. That is the meaning of delivering a detained person to the proper judicial authority. Eh kung isinama niya ang tao, eh di lalong mabuti, eh paano kung matakasan siya? Di otro kaso pa sa kanya. Nadidemanda pa siya ng infidelity in the custody of a person under detention. Now, who is that proper judicial authority? They are judges of the ordinary courts. It does not include the prosecutor. Even if we have rules on inquest proceeding, a person arrested by the police for having committed a crime is, as a matter of the rules of court, Section 6, Rule 112, should be brought before the inquest fiscal, inquest officer, who shall determine whether the arrest was valid and whether there is probable cause in order to warrant the immediate filing of information against the accused. But the presentation of the accused to the fiscal is not covered here. What is then the effect of bringing the accused within that number of hours mentioned in Article 125 to an inquest officer? That will insulate the public officer from being prosecuted for arbitrary detention, because it is not the police officer who will eventually file the information in court. It is the fiscal. So why will you fault the fiscal? I mean the police officer. Why the information was not immediately filed in court? It is incumbent upon the prosecutor. So the policeman is insulated from being charged. It is a matter of defense on the part of the policeman, because they follow the rule established in the rules of court. Those who are affected or arrest under the warrantless arrest provision, they shall bring the person to the duty inquest officer. In Manila, we have 24 hours duty. I was then the chief inquest prosecutor of the city of Manila before I opted to retire, because I'm already fed up with government service. I want to return to the life of an ordinary citizen of the Philippines. But when I retired, I became a person with dual citizenship. I am a Filipino citizen and a senior citizen. Dual citizenship. All right. Article 125 does not cover a situation where the arrest was by virtue of a warrant of arrest. This is the provision that covers warrantless arrest. A police officer who is armed with a warrant of arrest issued by the court, he arrests the person named as the accused in that warrant of arrest. He does not pay him to the judge or the court, nor place him inside the detention cell. He brought the person who he arrested by virtue of the warrant in his safe house. He placed him there for 1 week before he ultimately presented it to the court. That policeman will not be guilty, nor be considered to have violated Article 125. Because there is already a process issued by the court that accused who was arrested had been subject of a proceedings. And Article 125, wala pa itong judicial proceeding. The person there who is detained was the one arrested under the warrantless arrest provision. And that's why there is duty or obligation on the part of the policeman to comply in order to prevent him from being charged with violation of Article 125, arbitrary detention for delaying the delivery of a detained person to the judge to a proper judicial authority. Now, for how long shall the policeman or public officer who effected a valid warrantless arrest could detain him without filing the complaint? Well, the law enumerates. For those crimes committed by that person who was detained by him, if the penalty prescribed by law for the offense committed is afflictive in character, meaning to say prison mayor and above, then the policeman may detain him within a period of 36 hours. Within that 36 hours, he must file the complaint in order to comply with the duty of delivering the detained person to the proper judicial authority. But if it is already over 36 hours when he files the complaint before the proper judicial authority, then he is now to be prosecuted for violation of Article 125, delay in the delivery of a detained person to the proper judicial authority. Now, if the offense committed by the detained person is punishable only with a correctional penalty, then he shall have the right to detain him for only 18 hours. Within that 18 hours, he has to comply with his duty to file the complaint. If it exceeded that number, the same. It is violation of Article 125. And lastly, when the penalty for the crime committed is, it's only a light penalty. Light penalty. Those punishable by arrest or a fine of not less than or not more than 200 pesos. They are light penalty. So, they could be detained. This detained person could be detained only for a maximum period of 12 hours. Within that period, the officer has to file the complaint. If it goes beyond 12 hours, then he will be guilty of violating Article 125. Suppose the policeman has actually filed the case against the arrested or detained person, but it is already beyond those number of hours, 36, 18, or 12. Will that filing of the complaint cure the illegality of detention, thereby exempting him already from the penalty for violation of Article 125? The answer is no. The subsequent filing of the complaint by the police officer will not cure that illegality of detention. He is still to be proceeded against for violating Article 125. But the person detained may waive the provision of Article 125. How? By executing a waiver of the provision of Article 125. It is valid, provided that when he signs that waiver, he is assisted by a counsel, whether of his own or given by the police, as long as he is not a policeman himself. Because this lawyer who will assist him must be an independent counsel. It is not a policeman. A lot of policemen are lawyers, you know, but they are not authorized to represent the detained person who wanted to waive the provision of Article 125. If he waives it, then the fiscal will subject the complaint against him to a regular preliminary investigation. Meanwhile, he is under detention. He could not claim that he is illegally detained because he had already executed that waiver of the provision of Article 125. Under the rules, the preliminary investigation shall be terminated within 15 days. But you know, that is only it is not mandatory because in our experience, the preliminary investigation will continue or will reach up to 6 months. 2 months, 60 days. Sometimes 90 days if there is a special reason and the chief of office approves the request of the investigating officer. If not, if he is not able to terminate that, well, either that he shall suffer the penalty for to be meted during administrative proceedings, and meanwhile, all his allowances will be suspended. Even the salary will be suspended. Kaya yung mga prosecutors natin sa field offices ng Department of Justice, natatakot sila, lalo na kung yun lang ang source of livelihood nila, tatapusin din yung preliminary investigation to comply, termination thereof within the prescribed period. So, yung natawag na inquest proceedings should be understood in relation to Article 125 of the revised penal code. Marami pa ang hindi nyo actual experience about this inquest so-called. It is in relation to Section 6 of the revised rules of criminal procedure. Whenever there is a valid warrantless arrest effected by police, the police is duty bound to present the arrested person to the duty inquest officer, who shall determine two things. Was the arrest valid under the provision of Section 5, Rule 113? Is there probable cause to support the filing of information in court? If this no concur, then the fiscal may advise, all right, continue detaining that person. But if the arrest is not valid, and even if it is valid probably, but the fiscal's finding is that there is insufficient proof to support a probable cause against the accused, then he will order the release of the accused and set the case for preliminary investigation. That is my power when I was the chief inquest prosecutor. Even the first gentleman Arroyo, kinokontak din ako. Kung minsan pinapagalitan pa. Kaya lumala pa naman ako. Sabi ko, sir, tama naman yung ginawa ko. Hindi naman pwede yung ganun eh. Then, Nonong Cruz, the legal counsel in Malacanang, will talk to me. Chief, saan ba? Galit na galit sa'yo si first gentleman. Bakit daw ganun naging resulta ng iyong inquest? Eh, kako sir, kako ganun. Secretary, ganun naman talaga yung nasa pala. Meron ka bang authority? Yes, sir. O sige, pagupuntahin ko yung bata ko dyan. Pakala mo yung authority mo. Kung maaari, yung excerpt na, para hindi na kami mag-research pa. So, pupunta rin pa yung assistant lawyers ni Nonong Cruz, yung dating legal counsel na ni Sasaeng. Pakaraan nun, pinahapunan, tatawag sa akin si Nonong. Chief, mag-relax ka na. Naintindihan lang yung tama ka raw, sabi ni First Gen. I know, the First Gen will understand me. The correctness of my action, ay abogado rin naman siya, di ba? Abogado siya. Classmate na niya si Ombudsman Mercedes Gutierrez. Hindi pareho silang magaling.
Kaya pala. Pareho.
Okay, wala akong naging kaso. Minsan, si Mrs. Estrada naman, si Doktora, yung bata rin, violation ng 7610. Bakit daw gano'n? Nagreklamo sa kanya niya. Ma'am, meron ba kayong katabing abogado dyan? Wala. Sige, tatawagin mo na. Mag-usap kayo. Usap kami. Iwanag ko doon sa abogado. Siya nagpaliwanag kay Dr. Lloyd Estrada. Tapos, biglang tumawag sa akin si Lloyd Estrada. Chief, thank you. I became educated in that point. Tama pala yung ginawa mo. So, kaya kung ikaw ay naabala ko, kita mo. Mabait naman si Dr. Well, kaya pala naman sabi, if you know the law, and you know that you acted in good faith, kahit na pa sinong-sipo na sila, hindi dapat katakutan. You stand for what is right. Alam mo kasi, pagka ganito, if a man surrenders when he is wrong, then he is honest. If a man surrenders when he is not sure, he is wise. But a man who surrenders, even if he is right, then perhaps he is a husband. Okay, it's already 10:30. Let's take a break. Yung mga that is probably the reason why it's included under crimes against fundamental laws of the state. Hello. Now, the last kind of classification of arbitrary Article 126, delay in the release of that detained person. Reading that article, there are three distinct situations which could be each penalized if committed by the detaining officer. Number one is delay in the execution of the judicial or executive order to release the detained person. When you speak of judicial order, it means order issued by the court for the release. When you refer to executive order, it could pertain to release order coming from the prosecutor. If without reason, the public officer who is in custody does not execute the order of release, then he shall be guilty under the first form of violating Article 126. Here, remember that in both Article 125 and 126, the detention is legal from the beginning. It becomes arbitrary only later on. In Article 125, when there is a delay in the delivery of the detained person to the proper judicial authority, that arbitrary detention is committed. In the case of Article 126, from its inception, the detention is valid and legal, but it becomes arbitrary only when the officer is liable for any of those three acts enumerated. The second one is delay in the giving of notice of such order to the detained person. Now, delaying the giving of notice of the executive or judicial order of release without just cause shall also be act of arbitrary detention. And lastly, delay in the proceedings in any petition for the liberation of a detained person. So this pertains to petition for habeas corpus, the expedious remedy that may be availed by a person who claims to be illegally detained of his liberty. If the officer delays the proceedings, then he shall be guilty for violation of Article 126. Then we have the crime of expulsion under Article 127. Again, public officer or employee who without any lawful authority shall expel a person from the Philippines or compel him to change his residence. Now, with respect to the expulsion, remember only the President of the Philippines and the Bureau of Immigration and Deportation after appropriate proceedings can expel an alien from the Philippines, the undesirable alien. Can public authority in the Philippines expel a Filipino citizen who is undesirable? The answer is no. If a Filipino is undesirable in his own country, what country will be willing to receive an undesirable Filipino? So it pertains only to a foreigner. And also, the court may order the deportation in a judgment of conviction. But remember, the deportation is always accompanying the sentence of imprisonment. And deportation will follow only upon service of sentence. You know, there was a Chinaman who was convicted and sentenced to suffer long term of imprisonment and deportation. Upon reading the judgment, the sentence, he stood up and said, Your Honor, pwede po ba ako hiling lang ng counting pabor? Sabi na, bakit? Anong gustong pabor? Pwede po ba una muna deportation? Now, with respect to the last portion, that is compelling a person to change his residence or domicile, this is a violation of the constitutional provision of liberty of abode and of changing the same under the Constitution's Bill of Rights. Now, if it is a private individual who commits that act of compelling a person to change his residence without lawful cause, the crime would be grave coercion under Article 286. That is the right. The legal way of compelling a person to change his residence is by order of the court, like in ejectment proceedings, or when there is an expropriation proceedings, or when the accused is convicted of a crime and sentenced to suffer the penalty of disquero. By force of that penalty, if the prohibited area where he could not enter is where his residence is located, then he could not enter that area because it will be a violation of the penalty of disquero, and he will be subject to punishment for violating Article 157, the crime of evasion of service of sentence. Then, ito, siguro, importante ninyo dapat na malagay sa isip. Halos sigurado ako na may lalabas na question dito. What are the three forms or what are the different classification of violation of domicile? Now, there are three. They are covered by three successive articles, 128, 129, and 130. Now, under Article 128, I would say that is the so-called violation of domicile proper, because that is the only article among those three successive articles which has for its caption violation of domicile. And who is liable for that crime? Any public officer or employee who, without proper judicial authority, shall enter the dwelling of another, number one, against his will, number two, when that public officer conduct search without the previous consent of the owner, and number three, when that public officer surreptitiously enters that house or premises, and when discovered and when demanded to leave by the owner, he refuses to leave. By his refusal, he becomes guilty of violating Article 128. Each of these three acts, if committed, is punishable. So, repeat, the public officer must be without proper judicial order, meaning without search warrant. And then he enters the dwelling of another against his will. Number two, he effects search without the previous consent of the owner. And number 3, when he enters the house or premises surreptitiously, but when discovered by the owner and demanded to leave, he refuses to leave. Let's go to the number 1. That entrance against the will of the owner does not necessarily mean that it is entrance without the permission of the owner. It has been explained in many decisions of the Supreme Court that that phrase against the will must be understood to mean entrance against the express prohibition or entrance against the implied prohibition to enter. Where is there express prohibition? If there is the owner there in his house and when asked by the police or any public officer if he could enter, and the owner of the house, may warrant ka ba? Wala po. Ayaw kitang papasukin dito. Express prohibition. Assuming na yung may-ari, pero laki-laki naman ang karatula, do not enter. Express prohibition din yun. Pag pinasok niyo yun, kahit na wala yung may-ari, that is violation of domicile. What is an example of implied prohibition? Alright, ito si Mang Tomas. Hindi siya yung may-ari na Mang Tomas Lechon, ha? Si Mang Tomas, ito kapit-bahay namin. Na walang hanap buhay. Okay? Nandun siya harap ng bahay, pumasok yung polis, kung dumating. Mang Tomas, pwede po ba pumasok sa bahay niyo? Nag-uusap lang po tayo. Sabi ni Mang Tomas, ay, ayaw ko, wala akong waran. Wala akong gano'n makipag-usap sa polis. So, the policeman pretended to leave. But he just go around the house and finding that there is an open window, he climbed the window and enters the safe. Now, what is that entrance? Is it against the express prohibition or implied prohibition? It is considered, according to the court, implied prohibition because windows are never for the purpose of entrance. Windows are intended for young women to look out and see the passing young and passing men. And for men to look outside and see the pretty faces and beautiful lips of women. That is the purpose of a window, but never for entrance. So we have not. Suppose Mang Tomas was persuaded to give permission to enter. Okay, sabi ni Mang Tomas, sige, gusto mo pala akong makausap. Okay, ano pa yan ating pag-uusap? Once inside the house, the policeman never asked his permission. He draws his pistol, but it is not aimed to Mang Tomas. And then went inside all the rooms there and conducted search until he was found a unlicensed firearm, caliber 45 pistol. So, because of the discovery of that unlicensed firearm, he seized the same and arrested Mang Tomas for and charged him with violation of PD 1866 as amended by Republic Act 8294 for illegal possession of unlicensed firearm. So, it was filed before the fiscal. Then, on the, as a counter charge, the accused, I mean to say, Mang Tomas filed a counter complaint against the policeman for violation of Article 128, violation of domicile. Question, which of these two charges could prosper? Is it the charge filed by the police for illegal possession of unlicensed firearm? Because Mang Tomas was found to be possessing an unlicensed firearm, or the charge against the policeman by Mang Tomas for violation of domicile. Let's dissect the facts. Ito ang kasama sa multiple choice question. To give you an idea on how to answer multiple choice question first, power of recall. What we are doing here now is to improve your power of memory, which includes power of recall. Recall the provision of law and the precepts or principles that are applicable, and then from the facts, learn how to analyze. Now the facts are there. How will you analyze? Because the question is, which one will prosper? Alright. Since this crime of violation of domicile is violation or is committed in violation of the Constitution, What is the provision of the Constitution that is violated by crimes punished, where the crime committed is violation of domicile? The right of the citizen against unreasonable searches. That is the provision of the Constitution. When Mantomas gave his permission to enter for them to talk, that's all right. But it does not carry with it the consent to conduct search of the house, because that fall under the second act that is punished under Article 128, conducting search without the previous consent of the owner. It implies that aside from the permission to enter, the policeman must ask for a consent because of the word without the previous consent. It implies that the policeman should ask consent to effect the search. Now, you will say, hindi niya piligian, di ba meron tayong principle na merong express waiver or implied waiver of the constitutional right? Well, the Supreme Court in the case of People versus Banto, under the same set of facts, the Supreme Court said the conduct of search is in violation of the Constitution because there is no valid waiver of the rights. There are prerequisites before the right against unreasonable search under the Constitution could be waived according to the Supreme Court. One, there must exist that right. The right exists in favor of that person, Mantomas. And Mantomas is aware of such right that exists in his favor. And number three, that he shall knowingly waive his right to it. Since absent any of these prerequisites, or all the prerequisites are absent, then that is violation of his right. And it does not conform to the second punishable act mentioned in Article 125. The search was without the previous consent of the owner. Since there is violation of his constitutional right, all those evidence that persist in violation of that right shall be rendered inadmissible in any court as evidence. So Mantomas, the charge against Mantomas shall be dismissed, because that confiscation or seizure of that contraband cannot be used as evidence against him because of the violation of his right against unreasonable search. Then Mantomas' complaint shall prosper because the public officer was without judicial warrant and he effected a search without securing the previous consent of Mantomas. That is how this Article 128 should be understood, especially with respect to the first and second act mentioned therein. What about the third one? The public officer or policeman was without any search warrant. He secretly, surreptitiously, able to enter the premises, but because perhaps he created some noise, the owner discovered him. And then, the owner was now very curious. Bakit ka narito sa bahay ko? Hindi naman kita kilala. Lumabas ka. Okay. Pag lumabas siya, wala siyang kasalanan sa Article 128. Pero kung hindi siya lumabas, despite the demand of the owner, then that third act is being committed. He shall be liable for violation of domicile. But even if he lives upon being demanded by the owner, but the question is not what is the violation of Article 128. That is not the question. The question is there any crime committed by that police officer? So, hindi na kamukha doon sa unang answer ang magiging sagot nyo. Doon sa una, kung lumabas na siya, wala siyang violation of 128. Pero, hindi naman nangangahulugan na wala siyang crime na nakomit. Noon bang pumasok doon yung police at nag-search, hindi na naman ang may-ari. Halimbawa kayo may-ari ng bahay, nakita niyo yung police. Ano ang magiging reaction niya? ay naku, salamat naman, kahit hindi kita kilala, pumasok ka sa bahay ko. Ganun ba magiging reaction nyo? O masamang masama ang loob nyo, gusto nyo nang sugurin ng pulis dahil sa bakit siya pumasok niya nang walang pahintulot nyo. Ganun ang magiging tunay na reaction ninyo. Kung ganun ang magiging reaction ninyo, ano ang crime na nakumit ng pulis? Then you will consult Article 287, the lightest kind of coercion, which is unjust vexation. That is the crime committed by the police. What is unjust vexation according to the latest decision of the Supreme Court? It is any conduct or act of a person, although not capable of inflicting physical harm, nonetheless causes irritation, vexation, or annoyance upon an innocent person. That is the crime committed by the police. Not violation of domicile under the last act mentioned in Article 120. It is falling under Article 287, the so-called unjust vexation. All right, the second form, Article 129, that is maliciously procuring a search warrant or using unnecessary severity in executing one that is validly issued. But take note of the opening sentence of this article. In addition to the liability that may attach to other violation or offense committed, the penalty under that provision shall be imposed upon any person or a public officer who shall procure maliciously a search warrant or shall exceed authority or employ excessive severity in the execution of a search validly issued. What is the legal significance of that first portion, the opening sentence of Article 129? It implies that the officer may have committed another crime other than violation of Article 129. Why? Because in addition to the liability for some other offense that may have been committed, the penalty of provided in Article 129 shall be imposed likewise. So there is no complexion there, but two separate crimes. Maliciously procuring a search warrant. How is search warrant being secured? By means of application for the issuance of search warrant. And what is one of the requirements? To attach thereto an affidavit. An affidavit. Now, suppose the applicant executes an affidavit and then he made a deliberate assertion of falsehood on a material matter required by law, under law. And because of that falsity, he was able, the court was persuaded to issue a search warrant. Alright, the search was effected, the result was negative. Because there was actually none that could be found in the premises to be searched. Perhaps the applicant only applied for it to cause some harassment or whatsoever against the person to whom the search will be effected. Now, in that situation, we will follow the first sentence of Article 129. What two crimes were committed here? There is the crime of perjury, first, because he made a deliberate assertion of falsehood in an affidavit required by law on material matter required by law, under oath. And number two, the reason for the procurement is malicious. So two crimes are to be prosecuted against the offender: perjury and maliciously procuring a search warrant. And he will be convicted of these two offenses if proven by strong and competent evidence. Now, with respect to the employing unnecessary severity, suppose there is a search warrant The object of the to be searched are, let's say, paraphernalia, drugs paraphernalia, or contraband like firearms that are not covered by license. So they have a legal reason to search. But then there was unnecessary severity and there are other intentions on the part of the police. Instead of just opening the wardrobes, the cabinets, without destroying, they destroy the same left and right. But they have a purpose. When they see a jewelry box, which certainly will not contain a firearm, they take it and packet it the same. But they use force upon things in doing so. Excessive severity. Although they were able to find this contraband, nakakuha sila ng firearm doon sa ibang lalagyan. But the fact that they exceeded their authority or employ unnecessary severity because of their intention to take something more than that firearm, then what two crimes will they be charged? Violation of Article 129 or employing excessive severity in the conduct of sex. But they also use force upon things for the purpose of robbing. So they shall also be independently charged of robbery in order to apply the first portion of Article 129. In addition to the liability for some other offense that may have been committed, the penalty under this provision shall be imposed. So there could be no complex crime because the provision speaks of independent and separate penalty. Please have that in mind. Marami kasi hindi nakakaintindihan kahit kayo nagpa-practice na. Pero yung mga pulis magaling. Pag nagpa-imbestiga, ang demanda, lahat na makikita sa libro, theft, malicious mischief, lahat na. And violation of domicile. Mas magagaling yung mga investigador ng polis. Pero yung mga practicing lawyer, hindi nila sinasabi yun. Kasi hindi nila nakita yung provision na yun ng Article 129, yung first portion, in addition to the liability for some other offense that may have been committed. The penalty of so and so shall be imposed. Then let's go to Article 130, the last crime of violation of domicile. This is committed by the public officer in those cases where search is proper, but they effected the search without the presence of the owner of the house or a member of the family, or in the absence of those two, in the absence of two witnesses who belongs to the same locality. Now, what is the purpose of the law in punishing search conducted without witness? To prevent abuse of power, and more particularly to avoid this habit of the policemen to plant evidence to innocent victims, to implicate them for some false prosecution of an offense. That is the purpose there. So, there is no owner of the house, no members of the family. Pero itong mga searching party, search warrant could be issued by a court in the place other than where the search shall be conducted. Di ba? Okay. Yung Manila Court nag-issue ng search, Quezon City Court nag-issue ng search warrant which shall be conducted in Manila. Kasi alam na nila yung tao rin sa bahay na yun, umalis, nagbabakasyon, so walang tao. They brought two witnesses from Quezon City. And when they arrive at the place, they break open the door in the presence of the two witnesses and began searching. And then, after searching, they got all those that are covered and have been signed by the two witnesses which came from Quezon City and not belonging to the same locality where the search was conducted. What is the crime committed by those police officers? The same crime, violation of Article 129. That is the crime. It is as if a search was conducted without any witness at all. It could easily be understood why the law requires that the witness should be coming from the same locality. Because those people in the same locality can properly observe what the police will do and probably still in favor of those person of the owner of the house. Pero pag nandoon galing sa ibang jurisdiction, hindi naman galing doon, ito'y kakuntsaba ng mga pulis. Kahit na anong gawin nila ng mga pulis, pwedeng gawin. At kung kasama nila yun, nakakuntsaba nilang witness, hindi naman magsasabi ng masama laban doon sa mga pulis na nagsama sa kanila doon. So para din walang the crime is still violation of domicile by searching without the presence of the required witnesses provided under Article 130. That is the crime. Article 130, I mean, yun pala yung last. Kamay lang ako ng pagkasabi dyan. Alright. Let's go now to Article 131. That is 131, prohibition, interruption, and dissolution of a peaceful meeting. Now, this is also committed by a public officer who have no legal ground. And that public officer should not be a participant in that peaceful meeting. Because if he is a participant in that peaceful meeting, it is not the crime that would be charged against them. It is violation of Article 153, that is disturbance of public order or unjust vexation, as the case may be. But if the public officer is not a participant in that peaceful meeting, and then without any legal ground, he interrupts or dissolves or prevents the holding of that peaceful meeting, then that public officer is guilty of Article 131. Now, suppose in the crime against this interruption of religious worship, crimes against religious worship, there are only two kinds of crimes against religious worship: interruption of a religious ceremony and offending the religious feeling under Article 133. Now, Article 132 punishes any public officer who shall prevent or disturb the holding of a ceremony or manifestation of any religion. Whereas, in the case of Article 133, crimes against religious worship, it is committed by any person. At the door of the distinction, Article 133 punishes any person. But in Article 132, definitely, it is a public officer who shall stop or disturb the holding of a ceremony or any religious manifestation. Suppose there is a religious rally or religious meeting at the Luneta grandstand. And in that meeting, the speaker was, let's say, a bishop of the Catholic Church. All those religious meeting is under the aegis of the Catholic religion. Then came two unruly members of the Special Action Force. And when they hear the bishop speaking, and part of the speech is pertaining to advising the faithfuls not to indulge in excessive drinking, upon being heard by the forefront, they began angry. They fired their gun and thereby dispersed the said religious meeting. What is the crime committed by the two? The Special Action Force, PNP. Will it belong to the crime punished by Article 131? Will it belong to the crime against religious worship, interruption of religious worship? Now, you should know the differences or difference between Article 131 and 132. In Article 131, it must be a peaceful meeting that is not a religious worship or religious manifestation. Is a religious rally or a religious meeting a religious worship? Now, it has been heard, it is not. What is this religious ceremony or religious manifestation? These are the traditional rites or ceremony of a particular religion. Especially Catholics, marami silang religious right. It is being recognized and acknowledged and being protected. Like for instance, the saying of Mass, the procession in honor of the different saints during fiestas. If any of this occasion, which is considered religious ceremony or religious manifestation, is interrupted, stopped by any public officer, then that public officer is guilty under Article 132. But since a religious meeting or a religious body is not a religious ceremony, then those two members of the Special Action Force of the PNP shall be guilty of violating Article 131. It will only constitute interruption or dissolution of a peaceful meeting. Now, with respect to Article 133, the offender, there is any person who shall perform an act which is notoriously offensive to the feeling of the faithful, whether it be during a religious ceremony or in a place that is devoted to religious worship. So there are two things to be considered. If a person, an offender, performs an act that is notoriously offensive inside churches. Churches and chapels are places that are devoted to religious worship. Even if there is no religious ceremony actually going on, as long as the act is committed inside those places which will offend the feelings of the religious, and the act is considered notoriously offensive, then that offender shall be guilty of a crime against religious worship under Article 133. Example, here is a person who appears to be tipsy. He went inside the Quiapo church. You know, there were several icons lined up. Accidentally, he lost his balance. He said, hit the protruding toe of one of the icons. Nasugatan siya dito. Nagalit siya. Siday pa mo ako, babalikan ko mamaya. After 1 hour, bumalik siya, may hawak ng pamano. Ito, walang visa to. Pinokpok niya yung icon. Aba, di nabasa. Ngayon, ano ang crime na nakamit ka? Hindi naman pwedeng physical injury dahil hindi naman buwan. Hindi yung karaniwang malicious mischief. Kung nasa labas yun, kahit na nasa labas yun, halimbawa, at may nakakitang religious, members of the religious, baka dito rin babagsak yan sa Article 133. Pero ito yung nangyari doon sa loob ng simbahan. So, the crime is an act performed or committed inside the church, and the act is notoriously offensive to the feelings of the faithful. Then he will be charged and prosecuted for violating Article 133. But if it is outside of the church, and there is, let's say, mass, and you know, in some places where there are no churches or chapels, then there is, for instance, Barrio Fiesta. Those group of elders who are Catholics will organize that a religious ceremony, that mass will be held. They will invite a priest from the town proper. So there is now a mass. There is no church. Now, during at the height of the ceremony, two persons who probably doesn't want the homily being said by the officiating priest, pinukol nila ng bato yung pare. Tinamaan yung pare. Nagkaroon ngayon ng bukol sa ulo. Yung mga tao ngayon, abay, di na-discuss. Now, what is the crime committed by that person? Then, it will fall under Article 133. Because there is ceremony, he performs an act that is notoriously offensive. Hindi ba offensive sa mga member ng kapot? Pukulin ng bato, tinamaan sa ulo ng kanilang pare. So, that is notoriously offensive. The crime is violation of Article 133, offending the religious feelings. Kung halimbawa, mahal na araw, ano ang religious ceremony na madalas nating maobserbahan? Pabasa ng pasyon. Now, there was a case decided by the Court of Appeals. In the chapel, there was a pabasa of the passion. Then, a group of persons began erecting tents to encircle the chapel where the singing of the passion was being held. So these elders was offended or were offended by that act. Pinahuli nila yung mga tao. Kaya dinimanda nila ng violation of Article 133. Convicted. So they appealed to the Court of Appeals. And on appeal, they were acquitted. They were acquitted of the violation of Article 133, but nonetheless, they were convicted under the provision of Article 287 for unjust vexation. To become an act notoriously offensive, that act must be addressed to the dogma of the religion. But when it is only incidental that they created noise, because erecting tents is not directed against the dogma of any church or religion, but it is offending. It causes vexation, irritation, or annoyance to those persons. So this is the appellate court said, if ever the accused are guilty, it is for the crime of unjust vexation and not for violating Article 133. Alright, we are now in a very crucial insofar as it's concerned these crimes against public order. Ano ba mga popular na crime ngayon? Rebellion, sedition, codita? O wala na? Hindi, meron pa. Dahil meron pa tayong mga brother Muslims who are engaged in the NPA, also are engaged in rebellion. Okay. Let's go now to Article 134. Rebellion or insurrection. You know, some authorities say that insurrection no longer exists. At kanilang legal basis, under the 1987 Constitution, unlike the previous Constitution of the Philippines, that word insurrection had been eliminated. What remains now in the Constitution is only the word rebellion and no longer insurrection. Kaya wala naman makikita ngayong mga charges against a certain person charging them of insurrection. Lahat ang nakalagay na charge for rebellion. Walang insurrection. Now, how is the crime of rebellion? And what is the nature of the crime of rebellion? Is this a crime against national security? The answer is no. Because the crime against national security, yung kinuha natin, yung didiscuss natin kanina sa Title 1. Etong rebellion is crimes against public order, a crime against public order belonging to Title 3 of the revised penal code. All crimes against national security belongs to Title 1, not belonging to Title 3. Now, rebellion is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to the government of the Philippines or its laws, the Philippine territory or any of its part, or any land, naval, or other armed forces, or to deprive the chief executive or the legislature of their powers and prerogatives. So there are two specified purposes in rebellion. that of removing the alien from the government of the Republic of the Philippines or its laws. The Philippine territory or any part thereof, of any land, naval, or other armed forces. And number two is to deprive the President, who is the Chief Executive, or Congress, the legislature, of their powers and prerogatives. But ultimately, you could say that the main and ultimate goal of the rebels is to overthrow the existing government in order that they could establish a government of their own. That is the ultimate goal of the rebels. Suppose 100 people they arm themselves and rise publicly, and they went to the Supreme Court and take over the powers of the Supreme Court. What is the crime committed? Is it rebellion? All right. Strictly speaking, you will consult the definition. What does it say with respect to the powers of the government? Only two branches of the government. It is the Chief Executive and the Legislature. Does it mention the judiciary? There is none. Now, what is the crime committed by those 100 persons who are armed and then prevented the Supreme Court from performing the duty? Then it will fall under the crime of sedition under Article 139. The offender rise publicly and tumultuously for the purpose of preventing the public officer from the execution or performance of their function or duty. That would be the crime. It will not become rebellion because there are only two departments of the government. If their functions are deprived by the rebel, the crime is rebellion. Now, our crimes committed by the rebels, and which are murder, homicide, robbery, theft, rape, while they are engaged in rebellion, could they be prosecuted for a complex crime of rebellion with murder and homicide? Or shall they be prosecuted for separate crimes of rebellion and separate crimes for all those private crimes that they have committed? Now, it has been ruled, and it is still fresh in your mind, the case of People versus Amado Hernandez, and the case of Elvile versus Judge Salazar of the RTC of Quezon City, where the Supreme Court reiterated that common crimes committed on the occasion of rebellion shall be considered absurd if they are committed in furtherance of rebellion. But if there is no political motive that could be proven why these common crimes are committed by the rebels, then there shall be rebellion as one charge and as many counts as of murder as there are people killed independently of the charge of rebellion. It is only when those killings were motivated politically where it could be considered that those common crimes are committed in furtherance of rebellion. Kahit na 1,000 pang tao ang pinatay ng mga rebels, the same crime of rebellion is committed. There is only one penalty. But if the rebels kill people because of personal revenge and hatred, which could not be connected to the political motivation, then this killing shall be considered as separate crimes from rebellion, as many count of murder or homicide. But about the crime of robbery or theft committed by the rebels, the same principle. If the purpose of the rebel in robbing the people and the government of their money is to use the money for the procurement of their goods and armaments, then that crime of robbery and theft are considered absurd. But if their purpose in robbing and stealing property and money of the people, including the government, is to pattern their own personal pocket, to send their children to the exclusive schools, buy cars for their children while schooling, that will not be considered absorbed in the crime of rebellion because it is not politically motivated, but personally motivated. Rape could in no way be considered absurd because there is no political color that could be ascribed in rape. Meron ba nanalo laban sa gobyerno ng mga rebelde kung ang kanilang gagamitin lang ay mang-rape ng mga babae? Wala. Lalo lang silang manghihina. Wala silang karapatang malalo. So, it has been here. This crime of rape is motivated by the personal lust, the bestial instinct of man, never connected to the political motivation in the crime of rebellion. So, rape is always a separate crime from rebellion, if committed by the rebel. Now, there is one special law that is mentioned by here in your syllabus. PD 1866 as amended by Republic Act 8294. This is the law regulating ownership, possession of firearms. Now remember the case of People versus Silino Sr. It was clearly explained by the Supreme Court that if the crime committed by the offender is with the use of unlicensed firearm, and the crime committed is, number one, murder or homicide, or when it comes to rebellion, sedition, and attempt to commit codita. 5 lang yun. 5. Doon sa unang crime na dalawa, murder or homicide, don't forget that the use of unlicensed firearm is only a special aggravating circumstance. The unlicensed firearm shall not be subject of separate prosecution. It is either homicide or murder only. But once that firearm is alleged in the information for murder or homicide and proven to have been used in the killing, that will only be considered as a special aggravating circumstance. If it is a special aggravating circumstance, it could not be offset by any ordinary mitigating circumstance. But with respect to the other crimes, I also included in my enumeration per the provision of law. Rebellion, sedition, and to commit codita. If firearms are used, then it is considered absurd and could not even be considered as aggravating circumstance. But with respect to other crimes outside of the fight and illegal possession, unlicensed firearm is used in committing them, then that is where the Supreme Court expressly provided the procedure, like robbery, kidnapping with the use of unlicensed firearm. In this kind of crime, because they are not included on those 5 expressly enumerated by the law, 2 informations must be filed in court. One for kidnapping or robbery, as the case may be, or any other crime outside of those 5. And the other information for illegal possession of unlicensed firearm. Does it mean that they shall be convicted of both crimes? It depends. If, for instance, in the crime of robbery, and the unlicensed firearm is also alleged in the information, once the accused is convicted of robbery with the use of that unlicensed firearm, then that other information for illegal possession of unlicensed firearm will be dismissed. It shall no longer be prosecuted. For what reason? Because under the provision of Republic Act 8294, a person may only be convicted of simple illegal possession of unlicensed firearm if such firearm has not been used to commit another crime. If it has not been used to commit another crime. It is like this. If a person has a gun, unlicensed, he was walking in the busy street, he was noticed by the police because he has a firearm tucked on his waist. So he was confronted. He was asked, meron ka ba diyang baril? May lisensya ka ba? Wala siyang maipakita. So in that situation, if he is charged for illegal possession of unlicensed firearm, he will be convicted. Why? Because definitely there is no crime in which the unlicensed firearm was used. Pero dito sa explanation ko, based on the case of Siligo Sr., decided in 2007, if in the information for robbery, the accused was acquitted. And since the charge was dismissed, there was acquittal, it was not proven that the gun had been used to commit a crime. So the information for illegal possession of unlicensed firearm will now proceed and be successfully concluded that will result to his conviction because the gun or the firearm is proven to have not been used to commit another crime. Assuming that the accused was convicted of robbery, but it was proven likewise that the unlicensed firearm was not used in any way in committing the robbery, then this information for illegal possession of unlicensed firearm shall also proceed because the gun, the unlicensed firearm, is not proven to have been used in committing another crime. That is the explanation of the Supreme Court in the case of People versus Siligo Sr., decided in 2007. Ngayon, meron maganda akong i-advise sa inyo pag may mga baril kayo na wala lisensya. Mapapansin kayo ng pulis nagkalakad. Tapos nakabukol. Kahit na kayo may t-shirt o may jacket, napansin. Oy Brad, meron kaya tang barila. Tumalikod ka. Bunutin mo yung baril mo, iputok mo sa taas. Commit alarm scandal. Kuhulihin ka ng pulis. Ngayon, ano sabi naman yung could not be punished for illegal possession of unlicensed firearm if that gun had been used to commit another crime. Ginamit niyo ng pag-commit ng alarm scandal, which is punishable only by arrest of minor. Absurd na yun doon. Magkas kayo, ano ba ang penalty under the new law? Kapag ka ang baril na nahuli wala lisensya, caliber 38 and below has a penalty of 6 pressure correctional in its medium in the maximum period. If it is caliber about 38, kahit kasama na yung basuka at kanyon, pasalagad na ng tao, ang penalty, repression mayor in its minimum period. Meaning, 6 years and 1 day to 8 years. Yun ang pinakamataas na penalty ngayon sa illegal possession of unlicensed firearm. O ngayon, kahit na caliber Armalite rifle ang ginamit ninyo, paputukin nyo sa taas, may alarm scandal. Huwag lang tatama sa ipaha. Dahil sa pagtutuma, delikado. O, kita nyo, i-demand naman kayo pareho. Siyempre, cover dito ng Siligo Sr. Di-demanda pareho. Ano ba ang ginamit sa alarm scandal? Baril. O, kung baril, guilty ka ng alarm scandal. Magmumag ka na ng dismissal na yun sa illegal possession of unlicensed firearm. Your Honor, I could no longer be convicted of illegal possession of unlicensed firearm because that firearm had been used to commit the crime of alarm scandal. Ganyan ang batas. Ganyan ang batas. So, understood, klaro na yan. Kaya huwag na kayong matakot na baka mahuli kayo. Kaya lang, pagka kayo puputok sa taas, huwag mong pakikita sa pulis. Kasi pag gulat pa lang, baka akala'y paparilin mo siya, paparilin ko na. Kaya, di ba? Uunahin ka na. Huwag mong papakita. Okay, we will continue this afternoon at 2 o'clock.